California, Mr. Kiley.
I yield back to the chair.
Yielding to the chair, I will use that time. Today, we're primarily talking about Section 8, Clause 8. I'll read it because it's short. Patent and copyright clause. It says, the Congress shall have the power to promote the progress of science and useful arts by securing for a limited time to authors and inventors the exclusive right to their respective writings and discoveries. Mr. Hartline, I'm going to start with you. On a design patent, what's the discovery?
So a design patent is a new, original...
It's an ornamental
design.
And is it true that the United States is one of the few countries that actually recognizes ornamental designs for purposes of a 15-year exclusion?
I'm not familiar with international patent law. I'm sorry.
Okay, well, let's just say...
It's been recognized here for over a century.
Right, we've had them for a period of time. They've had different periods and so on. But because they're ornamental in nature, does each part have to be uniquely ornamental, or does the patent office, to your knowledge as a professor, do they grant it based on what appears to be a distinctive, different design than the one that came in the day before?
I'm not a design patent law expert. When I taught patent law, I covered utility patents. I skipped design patents. So
I don't blame you, because design patents historically basically prevent your competitor from making a deceptively similar product. Would you all agree? I see the heads nodding. So much of the discussion today is, in fact, on protection that is granted by design patents. Much of what we're looking at doing is to modify, enhance, or define design patents in a way in which they do not exclude 6 or 7 or 8 years later that faded headlight that can no longer be polished to be usable from costing you $1,500 to $2,500 each in order to replace something that used to be available at the auto parts store for about $6. Mr. Roberts, you're shaking your head. Why don't you opine on that if you don't mind?
Yeah, I mean, you make a really good point, Chair Issa, and I mean, I think the point here is to focus on the downstream impact of these policies. And one thing I would point out, again, hashtag not a lawyer and also not in the auto business, but my understanding is the use of design patents has increased dramatically, even exponentially, in the last 10 to 15 years. If you go back to the 90s or 80s, you know, parts makers, automakers were not applying these types of patents to replaceable parts like bumpers and rear view mirrors. Somebody had a business decision that if you can do so, then we can capture more of that aftermarket by outlawing identical aftermarket replacements. That has a huge downstream impact on car owners and on insurers and on all of us. And so, yeah, I think you make a really valid point.
Well, in the time that Mr. Kiley has yielded me, I'm going to ask one more question that's salient to all of this, and that is, we haven't talked much about true parts. I happen to have one of Coparts, one of the major companies that recovers automobiles, totals them out, resells them, exports them, any number of uses, but generally they're receiving it from an insured in a total out. Now, historically, the founder of that company started off cutting parts off of Dodge and Chryslers and selling to people who then put them onto their vehicle and kept it running. Today, many of those items, and I'll start with Mr. Weiss, many of those items, because of the DMCA as it's presently interpreted, when you take the authentic transmission, the authentic radio, the authentic product off of a near identical make or model of a car, or for that matter, going further, even though that's not their business, an IBM computer, a Dell computer, whatever, in order to put these two original authentic products back together again, you need software which is not provided and which is being withheld. Is that correct?
That's correct. If I take a brand new iPhone 14, if I have 2 of them, and I swap the screens between those, you don't get full functionality back. You're missing a number of key features. Included in my written testimony, a chart of the increase in this parts pairing over time. And so we got our start doing exactly what your constituent did. We would disassemble laptops and sell the parts. And that is increasingly hard to do. We took a MacBook Pro, we took screens between 2 of them, and it just didn't work. Without a software tool that Apple makes. Of course, I'd like to maybe be able to make an alternative software tool to Apple's, but I can't right now.
Mr. Hartline, you've been quite an advocate today for some of these issues, perhaps in opposition to what we're proposing. But would it surprise you to know that, for example, IBM buys used parts back from companies that supply them in order to keep very old IBMs with important software on them, such as the IRS, when they no longer make them, while at the same time opposes allowing that same company to sell them to companies that are not using their, quote, maintenance, remembering that the maintenance is not IBM making the parts, but in fact buying them off the market. How do you reconcile that within the questions of what I said, which was this intellectual property question that we're looking at modifying in order to create a better right to repair market?
So I'm not familiar with the IBM story in particular, but what it sounds like to me is you've got somebody who has IP protection because they created something new, something useful, et cetera, and what do? They get a right to exclude. And so they can use that right to exclude to create business relationships and to increase their profits, which they in turn use on R&D, and we get more innovation.
My time has expired. I would cite for all of us that the first use and sale doctrine says you've given off those very rights when you sell those 2 IBM products that now are trying to be merged. With that, we'll go to Mr. Ivey.